Let me go ahead and put us on the record in cause number 2015614, the case styled Bradley Miller versus Virginia Dunn et al. Counsel, as always, I will take your announcements in the order in which your client appears in the style of the case. Before we get started, let me just say that we are, of course, conducting this proceeding remotely pursuant to the emergency order of the Texas Supreme Court, the most recent order being the 36th. And pursuant to that order, the court is allowing for these remote proceedings because of the existing pandemic. Even though we are conducting the proceedings in this fashion, I do want to remind everyone that no one is permitted to make any audio or visual recording of this proceeding. The proceeding is only to be recorded by the court's official court reporter, which of course is Ms. Williams, who is taking the record. It is a violation of this court's direct order to make any recording photographic, video, or otherwise of this proceeding. And so I want to be very clear that the court is proceeding under those circumstances and standards. And as you make your appearances, I would ask you to so affirm your understanding of that fact and of the circumstances under which we are proceeding. So I'll begin, of course, with the plaintiff.
Yes, Bradley Miller, pro se plaintiff, and yes, I affirm the understanding of what you just said, Your Honor.
Thank you. And we will begin with the announcements from the defendants again in the order in which they are listed in the pleading and are still before the court.
I think I would be the first one that's still before the court, Your Honor. Elena Eric, representing the estate of Marian Michalopoulos. And yes, I confirm your understanding of how we're proceeding.
Jennifer Littman on behalf of the Hockaday School, Your Honor. And yes, I confirm your directive of how we're proceeding.
Earl Nesbitt on behalf of Dallas County and Judge Diaz, and we certainly understand the court's directive.
I'm Scott Graydon on behalf of Judge Andrea Plumley. We understand the court's directive, and Judge Plumley has previously been dismissed from the lawsuit.
I think that is everyone. And I see that we have some other folks on the line who I'm assuming are persons who are observing the proceeding as it is their right to do. And so the court has before it this afternoon the defendant, the Hockaday School's Rule 91A motion to dismiss. Counsel, are you ready to proceed with your arguments thereon?
Yes, I am, Your Honor.
You may.
First of all, Your Honor, I would like to point out that we filed our motion to dismiss on April 19th of this year. The hearing has been set for today for several weeks. Under Rule 91A, Mr. Miller's response was due no later than 7 days prior to the hearing, or May 27th, last Thursday. He filed a response on Monday, Memorial Day. It's a 26-page response citing, I believe, 28 cases. We filed a brief objection and to the untimeliness of his response, as well as his attempt to use additional exhibits in today's hearing, and as well as just a brief reply. Mr. Miller last night around 11 o'clock filed a motion for leave for his late response. And I would just ask Your Honor that be denied. Mr. Miller, his response basically is that he's been busy. There's been multiple hearings in this case, and he's been busy with those. My understanding from my recollection and looking back at my calendar, the last hearing that we had on this case was on May 14th. So he had almost 2 weeks to prepare his response. So again, I would just ask Your Honor to deny his motion for leave on his response. I've reviewed some of his response in his cases, but I have not reviewed everything in deep detail. Essentially, Your Honor, Mr. Miller, as you know, based on all the documents that have been filed in the previous hearings, he's the ex-husband of Defendant Tally Dunn, who has previously been dismissed. He brought this lawsuit complaining of essentially a number of actions taken in some family court and other civil proceedings related to himself and Ms. Dunn. He sued Ms. Dunn, her attorneys, the two judges, two family court judges, two of Ms. Dunn's former employees, two police officers, the city of Dallas, the county of Dallas, an art dealer, Marianne Mikolopoulos, the estate of Marianne Mikolopoulos, who unfortunately passed away unexpectedly at the end of last year. And he's also sued my client, the Hockaday School, where his daughter with Ms. Dunn attends. Mr. Miller, I believe, apparently relies on the actions of Ms. Mikolopoulos to support his allegations against the Hockaday in this lawsuit. As you know, Your Honor, Rule 91A allows a party to file a motion to dismiss if the allegations in the pleadings, if there's no basis in law or in fact. A cause of action has no basis in law if the allegations and together with any inferences reasonably drawn from them do not entitle the claimant to the relief as a matter of law. And a cause of action has no basis in fact if no reasonable person could believe the facts pled. In ruling on the motion, the court can't consider any evidence outside the pleadings, but must base the motion on solely the live pleadings and the causes of action at issue. Your Honor, in our motion, we have asked the court to dismiss Mr. Miller's constitutional claims on the basis that there are no basis in fact or in law. On his constitutional claims, the general rule is that a private actor cannot be held liable for violations of the Constitution. That is, Hockaday's conduct alone cannot form the basis of a constitutional claim. From my brief reading of Mr. Miller's response, he appears now to be alleging a 1983 claim against Hockaday based on a conspiracy with Judge Diaz and Judge Plumlee. He cited a case, Dennis versus Sparks, in support of that. In support of that theory. Dennis versus Sparks, Your Honor, was a case in which a judge enjoined the production of minerals owned by some parties. That injunction was subsequently dissolved by an appellate court as having been illegally issued. After the injunction was dissolved, the plaintiff sued the judge and some other parties, alleging that the official act of the judge issuing the injunction was a product of a corrupt bribery conspiracy involving the bribery of the judge. The judge was dismissed from that lawsuit because of judicial immunity, but the court allowed the case to go forward against the private actors, stating private actors who corruptly conspire with a judge are acting under color of law. There's some important distinguishing factors between the Dennis case and the case before you. One, the plaintiff in that case brought the lawsuit after the appellate court had dissolved the judge's injunction as being illegally obtained. Here, to my knowledge, every appellate court and other court Mr. Miller has gone to has rejected his arguments that the orders issued by Judge Plumlee and Judge Diaz were void or illegally obtained. And I don't believe that they were ever declared invalid. And Mr. Miller has not alleged any meeting of the minds between the Hockaday School and either Judge Plumlee, Judge Diaz, or any other state actor. I would direct the court to two cases that are very similar to Mr. Miller's case, and in which the courts in those cases declined to follow the Sparks case. And the first one is Goodson v. I believe Magi, M-A-G-G-I, and the site is 2011 Westlaw 2533015. The second case is Westcott versus Stevens with a PH. The site is 219 Westlaw 1387715. In the Goodson case, Mr. Goodson was a pro se plaintiff who disagreed with some family court decisions that were unfavorable to him. In his lawsuit, he named judges, courts, court employees, county workers, social workers, foster families, the mothers of his children, her former attorneys, a guardian ad litem, police officers, a prison official, a sheriff, and state and federal prosecutors. While the court recognized the premise of Dennis, it found that Mr. Goodson had not plausibly pled a conspiracy between the state actors and the private actor who was the court-appointed attorney, because just the bald allegations of a conspiracy were not sufficient to infer any kind of an agreement or the meeting of the minds. In the Westcott case, Mr. Westcott also was a pro se plaintiff who had unfavorable family court rulings. He sued his ex-wife, her attorneys, and the law firm for a number of claims, including 1983 claims, citing various decisions by the judges and alleging that the judges conspired with other parties to deprive him of his constitutional rights. Again, the court recognized the exception in Dennis that a private actor can be sued under 1983 if there's a conspiracy, but again, declined to apply the Dennis case in that case because there were no plausible allegations suggesting that the judges acted corruptly or in concert with any of the private actor defendants. And conclusory allegations of conspiracy between a state actor and a private individual are not sufficient to state a claim under 1983. So in this case, Your Honor, again, Mr. Miller, like the pro se plaintiffs in those cases, has an issue with some unfavorable rulings in the family court case. And I've looked back through the pleadings to determine any allegations that Mr. Miller may have made against the Hockaday School and where he alleged any kind of conspiracy or a meeting of the minds with any state actor or anyone for that matter. In paragraph 76 on the petition on page 30, he alleges that Marianne Mikolopoulos wrote to Mr. Miller regarding her law firm's representation of a potential third party in her court proceedings. And she wrote, "My law firm's representation of a potential third party in your divorce is not a breach of fiduciary or an ethical duty." In the petition, Mr. Miller complains that Ms. Mikolopoulos failed to disclose that she had instructed Dunn and her attorney to request a gag order against Mr. Miller in what he calls a clear conspiracy to violate his constitutional rights of free speech. First of all, Your Honor, the instruction to Dunn and her attorney that he refers to throughout the petition or where he refers to it as instigating these unlawful proceedings against him is an email in which Ms. Mikolopoulos said that suggested that Dunn's attorney might seek a protective order. She didn't instigate any legal proceedings. She suggested that as an option. In paragraph 84 of the complaint on page 33, Mr. Miller stated that he suspected Ted Aiken, who was a retired appellate court judge, that he suspected Ted Aiken was handpicked to issue an unconstitutional ruling against Miller, and that the very strong circumstantial evidence glaringly suggested a conspiracy among Dunn, Ms. Mikolopoulos, Judge Slaughter, and Judge Aiken against Miller on behalf of Hockaday. The circumstantial evidence, I believe, which he is referring to, can be found in paragraphs 79 through 83 of the petition on pages 31 through 33, in which he alleges that the regular judge, Judge Slaughter, was absent due to her father being ill. So Judge Ted Aiken was sitting in for her on the day that Mr. Miller's anti-SLAPP motion to dismiss was being heard, that Dunn's attorney tried to smear him during the hearing, that Judge Aiken said he would talk to Judge Slaughter and would issue a ruling the next day. Subsequently, Mr. Miller learned that Judge Aiken had two daughters who had previously graduated from Hockaday and that Ms. Dunn knew. He also learned that Judge Aiken was a member of Brook Hollow Golf Club, where Dunn's grandfather had previously belonged and where Dunn had spent time as a child, and that Judge Aiken was also the former director of the North Texas MS Society, and Ms. Dunn has publicly claimed that she has MS. And he also learned that Ted Aiken had committed his father-in-law to a psychiatric institution and had subsequently been sued, and there had been a judgment rendered against him. But it's on the basis of these allegations, Your Honor, that he contends that there was a conspiracy against him. There's no allegation of any meeting of the mind, that there was any allegation that any actions be taken against him. And certainly there's no allegation of any communications or anything with a state actor. In paragraph 173 on page 71 of the complaint, he alleges that Dunn, Rochelle, and Findley sent Hockaday a copy of Judge Diaz's 2018 temporary orders. in violation of Texas Penal Code 32.48, and that Hockaday conspired in this act by intentionally recognizing the order as legitimate. In paragraph 235 on page 94, in the causes of action section, Mr. Miller alleges that defendants Dunn, Rochelle, Findley, and Mikolopoulos, and by extension, the Hockaday School, have conspired in Eighth Amendment violations by instigating, filing, and prosecuting the fraudulent cases that resulted in what he contends are his constitutional violations. Again, Your Honor, there are just simply no factual allegations in the lawsuit that Hockaday, that Ms. Mikolopoulos on behalf of Hockaday, or that anyone else for that matter, had any meeting of the minds or acted in concert or conspired, with Judge Plumlee or Judge Diaz, Judge Aiken, or any other state actor to deprive Mr. Miller of his constitutional rights. The unfavorable rulings in this case in the family court proceedings date back to sometime in, I believe, March or February of 2013. And he also alleges that he filed complaints with the State Commission on Judicial Conduct against Judge Plumlee and Judge Diaz, but makes no allegation of any adverse finding against them. And so, Your Honor, on the constitutional claims, to the extent they're based on 1983 conspiracy claim, we would again assert that there's no basis in law or in fact to uphold that claim, and we ask that it be dismissed. In his response, Mr. Miller also again asserts a 1985 claim. There's no allegation of a 1985 claim in the petition. Mr. Miller could have at any time between the time that this was brought up in a prior hearing until 3 days ago filed an amendment to his petition. He has not done that. He should not be allowed to amend to assert a 1985 claim at this point. There again are simply no allegations. A 1985 claim, although it does not require a state actor, it does require a conspiracy for the purpose of depriving a person or a class of persons of the equal protection of the law, and an act in furtherance of that conspiracy and an injury. Your Honor, Mr. Miller has provided you with 85 pages, 207 paragraphs of what he contends are factual allegations. That doesn't include the rest of his complaint where he asserts his causes of action. And there are no allegations to support any conspiracy by Hockaday with anyone to deprive Mr. Miller of his constitutional rights. The fact that Ms. Dunn attended Hockaday, was once on the board and was the president of the board of Hockaday, that Hockaday is following court orders that have never been declared illegitimate or void, that Hockaday has allowed Dunn to chair a fundraising event, etc. None of these types of allegations plausibly assert any type of claim of conspiracy or a 1985 violation. Likewise, an email from Ms. Mikolopoulos from her law firm account to Ms. Dunn's attorney and Ms. Dunn suggesting that what if you move for a protective order, there's no basis to conclude that that was any attempt to conspire with them. There was no, insistence that they do it. Ms. Mikolopoulos didn't file anything on behalf of Ms. Dunn or on behalf of Hockaday. So those claims, again, Your Honor, there is no 1985 claim pled. It should not be allowed in this case. Mr. Miller has also asserted a fraud claim against the Hockaday School. A fraud claim requires that there be a material misrepresentation of fact that was false, that Hockaday knew or should have known it was false, that it was made with the intent that it be acted on, that it was relied on, and that it caused injury. Again, there's no allegation in this in the complaint or in the petition that there was a representation made to Mr. Miller that he relied on. In the response, I believe his argument is that Hockaday represented to him that the court's orders were legitimate and that they knew that those orders were false because he told them they were false. And that's just simply no indication of any allegation that Hockaday knew that the orders were false. And he also says in his complaint that he relied on those based on some statement that Hockaday said they would call the police on him. There's no allegation in the petition to that effect, Your Honor. He also appears to allege that in response to the representation by Ms. Mikalopoulos that that she told Ms. Dunn and her attorney, what if you file a protective order? That was somehow a representation of material fact. First of all, a suggestion about filing a protective order is not a statement of fact. It couldn't be true or false. It was a suggestion. There was no requirement that anyone act on it or that they, should act on it. And there's no allegation or no allegations indicate that Ms. Dunn and her attorney did act on that statement. That email that he is referring to is attached, I believe, as Exhibit 2 to his petition. It was sent on November 10th of 2014. The next action filed by Ms. Dunn, I believe, was filed in February of 2015, some 3 months later. So again, Your Honor, we would just assert that there are no allegations in the petition that plausibly state a claim for fraud, and we would ask that they be dismissed. Mr. Miller has also alleged claims for conspiracy against his rights and to defraud. First of all, as put forth in our motion to dismiss, many of those theories are based on criminal statutes that provide no private cause of action. And so there's just no basis in law for those. Also, because Mr. Miller has failed to state a plausible claim of fraud, his conspiracy to defraud him must also fail. And again, his pleadings fail to sufficiently allege a conspiracy or any kind of meeting of the minds to defraud him, and therefore his claims should be dismissed because they have no factual or legal basis. And finally, Your Honor, Mr. Miller has alleged a claim of intentional infliction of emotional distress. Again, there's no basis in law or in fact to support this claim against Hockaday. Hockaday has merely complied with the court orders issued by Judge Diaz and Judge Plumley, a court order that Mr. Miller claims is invalid, but no other court has declared is invalid. And that's all. That's all that Hockaday has done. In his motion for leave that he filed last night at 11 o'clock, he objects to what he describes as bald-faced lying by Hockaday and me personally for mischaracterizing the void court order as being legitimate. But again, Your Honor, there's been no allegation in the petition that any court anywhere in the land, including the U.S. Supreme Court, which he has attempted to seek relief in several times, has declared those orders to be void or illegitimate. And so, again, Your Honor, there's just simply no basis in law or in fact to support Mr. Miller's claim of intentional infliction of emotional distress against Hockaday, and we would ask that you grant the motion to dismiss the claims against Hockaday with prejudice. As to the issue of attorney's fees, Your Honor, I'm aware that you have not thus far awarded any attorney's fees. To the extent you're inclined to do so, I would be prepared to present an affidavit after the hearing on the attorney's fees to date. I would just say, Your Honor, that Mr. Miller has continued to increase the attorney's fees that are being expended in this matter. Last week, he requested that Hockaday produce by Memorial Day 9 years worth of communications relating to him, his wife, and his daughter, and the various court proceedings. When we declined to do so, he filed an emergency motion for expedited discovery under the premise that it was necessary for today's hearing. Your Honor has told him in other hearings that I've been present in that outside evidence is not appropriate for a Rule 91A motion. And so those actions by him are just necessary and increasing the attorney's fees expended by my client. And that's all, Your Honor.
Thank you, counsel. Mr. Miller, you may respond.
Yes, Your Honor. Just initially with regard to the motion for leave to file response out of time, wondered if we could, if the court could rule on that before I begin my argument, because it would save a lot of time if I knew that my case law was going to be on the record prior to that. But just before we get to that, I want to address that issue first. I did file a response to Hockaday's motion to dismiss on the morning of May 31st, 2021. I was operating under the mistaken assumption that local rule 2.09 governed that process, which has a 3-day time limit, of course. I did not realize there was a 7-day limit, so that was my mistake. However, as you saw from Ms. Litton's presentation, she had plenty of time to review the case law in quite great detail and to write and file a response. So I think that that probably isn't an issue as far as the time she's had to respond and to review the pleading. And also, most of the arguments in my response have been iterated in previous pleadings and in previous hearings. So most of it is very little of that is new. I would bring up the fact that the court has allowed the Texas Attorney General's office to file briefs that did not comply with the local rule 2.09 3-day rule on behalf of Defendant Plumlee. So I asked that in the interest of equal treatment and due process that I be allowed to file my response out of time. It would also conserve the court's resources and the time we have today if I didn't have to read the entire response to get the case law on the record. With regard to the exhibits that attached to my response that Ms. Littman mentioned, I will say that Texas Rules of Civil Procedure Rule 91A6 specifically allows exhibits that are, quote, permitted under Rule 59, unquote. And Rule 59 states that any document, quote, constituting in whole or in part the claim sued on may be made a part of the pleadings, end quote. And the two exhibits I've attached to the plaintiff's response have both been mentioned repeatedly in my original petition. The text messages between Defendant Dunn and artist David Bates I mentioned on page 15, 20, and 45, and also at the original petition, Exhibit B at page 2. The recording of Defendant Dunn threatening to divorce me if our daughter didn't move to Hockaday immediately. I mentioned on pages 2, 17, 28, and 29 of my original petition. And the transcript is attached to my response as Exhibit B. That's from March 4th, 2015, from a hearing in the 191st Civil Court, to which Ms. Littman also alluded. Thus, both of the exhibits that I've attached to my response constitute part of the claim sued upon, and both are thus allowable under both Texas Rules of Civil Procedure Rule 59 and Rule 91A6. With regard to the claims, my claims under 42 United States Code Section 1985, I would like to bring to the court's attention that I filed a notice of special pro se litigant rights in this court on April 16th, 2021. And as indicated in that pleading, quote, the court is under a duty to examine the complaint to determine if the allegations provide for relief on any possible theory, unquote. And that's from Bonner v. Circuit Court of St. Louis, 526 Federal 2nd, 1331 at 1334. That's from the 8th Circuit, 1975, and quoting Bramlett v. Wilson, 495 Federal 2nd, 714 at 716. That's 8th Circuit, 1974. The court must also hold a pro se litigant's pleadings to, quote, less stringent standards than a lawyer's, and a pro se litigant who seeks relief for injury of constitutional rights, quote, is entitled to an opportunity to offer proof, unquote. That's from Haynes v. Kerner, 404 U.S. Code, U.S. 519 at 520 through 21, 1972. Certainly my extensive allegations in my original petition of conspiracy against my constitutional rights provide for relief under 42 United States Code Section 1985, paragraph 3. And this court is required by law to recognize that potential relief, even if it's not explicitly stated in my pleading. I would mention also that I'm specifically entitled to amend my petition under Texas Rules of Civil Procedure, Rule 63, and I plan to do so to explicitly include a claim under 42 U.S. Code Section 1985 and also possibly 1986, which is negligent infliction of harm. And for Ms. Littman to suggest that I should not be allowed to amend my pleading, which the Rules of Civil Procedure specifically allow for, would be a violation of my constitutional due process rights as well. So before I get into the main body of my argument, I would ask that the court give me some indication if my response that I filed will be allowed to be filed out of time, Your Honor.
Before the court rules, Ms. Littman, is there any reply that you desire to the various issues that have been raised in response.
Sorry, Your Honor, I had to unmute you. Your Honor, I'm not sure entirely. I would ask if the court is going to allow it, that if there's anything that Mr. Miller raises that I feel is necessary for me to submit a written reply to, that I be allowed to do so. I reviewed some of his cases, but as I stated, I believe that he cited 28 cases in his response. And when he suggested that I obviously had had a chance to thoroughly review them, I cited one of the cases from his response today in the hearing. So I have not been able to thoroughly review and digest and analyze and compare those cases with the facts of this case. And so if the court is going to allow that and it has an adverse impact, I would ask the court allow me to submit a supplemental reply brief.
And Your Honor, I have no objection to that at all. Hockaday would be free to file an additional pleading on this issue if they desire.
All right. Well, the court read your response in opposition to the motion, and so the court's inclined to allow for the argument, the briefing that you've submitted. On the other hand, these exhibits that are not attached to the pleading that is the basis of this lawsuit, particularly this reporter's record that you've attached as Exhibit B and these text messages, that these things were not included in the petition. And the Rule 91A6 states, as you referenced to some degree earlier, the court may not consider evidence in ruling on the motion and must decide the motion based solely on the pleading of the cause of action together with any pleading exhibits permitted by Rule 59. And Rule 59, of course, does permit that notes, accounts, bonds, mortgages, records, and all other written instruments constituting in whole or in part the claim sued upon or the matter set up in defense may be made part of the pleadings by copies thereof or originals being attached or filed and referred to as such, or by copying the same in the body of the pleading in aid and explanation of the allegations in the petition, or answer made reference to said instruments and shall be deemed part thereof for all purposes. So I look at that then to mean that if you had some documents attached to your pleading, then the court could consider those documents, but clearly the reporter's record from another proceeding in another court under another cause number was not included in the petition that you filed, and so the court is disinclined to allow for the exhibits pursuant to what I understand the rule to require, but will receive your brief and accept your brief. I've read it and I'm ready to receive your arguments regarding that. As it relates to the practical issue, which is that although the court is allowing leave for the acceptance of the late filed brief, if we get into a discussion about a specific case, given that there were quite a number of cases cited and counsel desires the opportunity for a letter brief, I understand you do not oppose that, and the court would be inclined to grant a short letter brief to be filed if that is necessary. With that, Mr. Miller, you may proceed with your arguments.
Thank you, Your Honor. First, my suit alleges that agents of the Hockaday School, including two chairs of the Hockaday Board of Trustees, defendants Virginia Talley Dunn and Mary Ann Michalopoulos, and the Hockaday School generally violated my constitutional rights, committed fraud against me, and conspired to commit fraud and to violate my rights. Specifically due to the actions of Hockaday and its agents, I've been subject to various illegal gag orders since 2013 and permanently since 2015, despite 4 appeals to the United States.
I'm sorry, Mr. Miller.
Yes.
Can you slow down?
Yes, sorry. Specifically due to the actions of Hockaday and its agents, I have been subject to various illegal gag orders since 2013 and permanently since 2015, despite 4 appeals to the United States Supreme Court, which has not heard any of my cert petitions, which is not atypical, of course. And I've not seen my daughter since May 18th, 2018. That's more than 3 years.
But Mr. Miller, if I could just interject for a moment so that I could make sure that I'm focusing on the chronology and the timeline as you've set it forward in your brief. As I understand it, at least the contention made in your brief is that for a period of time from, get the dates right, (2011) to 2013, Ms. Dunn was the chair at the Hockaday School of their board.
Yes.
And then following that, Ms. Defendant Michaelopoulos was the chair of the board from 2013 to 2015.
Yes, that's correct.
And in terms of the action that you contend is the activity on the part of the Hockaday School that is activity with state actors, the judges, that has caused you harm. You are making reference to the fact that at some point in time, I believe November 9th, 2014, you emailed the defendant and you copied the executive committee, or at least a member of the executive committee, but you emailed them regarding your divorce case and regarding the activities of Ms. Dunn. And there was a response to that email where, well, at least you contend that email resulted in an email being sent to Ms. Dunn and attorney Rochelle suggesting that they get a protective order because you were emailing the Hockaday School.
That's correct.
Okay. And that happened on November 10th, 2014.
That's correct.
Okay. And that email is actually attached to your petition.
It is, Your Honor, yes.
So if we go then to take a look at that email, I believe we are talking about the email that is denominated Exhibit B, and I'm looking at page 1 of 4. Is that right?
Yes, Your Honor.
Okay. And so in this email, which is sent from Marianne Brousseau, who we know to be the defendant that you've named here, who unfortunately has now passed away, sent from Marianne Brousseau to Rochelle, I'm sorry, prochelle@rochellerankin.com and to Tally Dunn. And in that email, it says, Patty, what if you move for a protective order based on this communication? I am not sure I will be able to get the school to do anything legally. I am trying. That's the conduct that you're saying is the activity that the Hockaday School, or at least its agent, engaged in with a state actor in order to violate your constitutional rights, as you've alleged it.
That is merely one of the incidents that I'm alleging. There are others.
But let's move forward from that. Tell me then, what is the other conduct that after this November 2014 email, what is the other conduct that you're alleging the Hockaday School engaged in?
Well, it's an unbroken chain of conduct. If I could, if you'll allow me to get into my timeline, it would become more clear. But I specifically, in addition to that incident, and that incident is, I believe, reflective of an ongoing dialogue, and well, more than just a dialogue between Marianne Michaelopoulos and Defendant Dunn, and perhaps other members of the Hockaday board. Of course, I can't verify that without further discovery, but sort of an unbroken chain between that point and probably prior to that email being sent in November 2014, that indicates a conspiracy to violate my rights. Obviously, that email was forwarded. The email that I sent on the previous day, November 9th, Defendant Michaelopoulos forwarded that email to Defendant Dunn and Defendant Rochelle, indicating that they should seek a protective order. I sent a subsequent email to the Hockaday board in December of 2014. And then in February of 2015, just a few weeks later, Defendant Dunn filed a suit against me in the 191st Civil Court seeking a gag order. This has been a long chain of gag orders that Ms. Dunn, in conjunction and conspiracy with Ms. Michaelopoulos and other defendants named in this suit, have sought and have been awarded against me. I was subject to a gag order during my divorce in 2013. It expired in 2014. Dunn didn't like me talking about her conduct during the divorce to Hockaday or to anyone, so she sought another gag order in civil court. Was awarded the gag order by Ted Aiken, who was an associate, a known associate of Miss Dunn, who had 2 daughters who went to school with Miss Dunn, who belonged to the same country club where Miss Dunn spent a lot of her youth. Clearly, they knew each other. They had a connection, as Ms. Littman indicated, through the North Texas Multiple Sclerosis Society. Ted Aiken didn't disclose any of these connections improperly, I believe. The coincidence of his showing up in that hearing to issue a gag order, I believe, was no coincidence. I think that any reasonable person would see that that's outrageous to even suggest that it wasn't planned, or the possibility that it was planned. So I appealed that gag order to the Fifth Court of Appeals. That gag order was overturned. Ms. Dunn knew that I was appealing, immediately filed, 4 days after that ruling. She filed for another custody modification suit in 2015, the one that I believe both of those suits were instigated by Ms. Michalopoulos. The timing and her email indicate that was a consequence of her direction.
So let me understand, because in the
Sure.
email that's attached, she poses the question to them, and she expressly tells them she doesn't think that the school will do anything. So on the basis of this email, you think that the Hockaday School, or her acting as an agent of the Hockaday School, that she's trying to instigate some litigation against you?
Yes, I believe. Well, first of all, this touches on vicarious liability. I'm alleging that Miriam Malopoulos, as the Hockaday board chair, was Hockaday, and the same with Ms. Dunn. The two of them were on the Hockaday executive committee at the same time, at the time of this November 10th, 2014 email and beyond. Ms. Michalopoulos actually stayed on the executive committee of the Hockaday board until 2017. She stayed on for 2 years as the chair of board governance and immediate past chair. So,
And by your statement, do you mean that you think that as a matter of law, that any actions they engaged in during their tenure as officers on the Hockaday board, that those actions then are actions for which the Hockaday School is vicariously liable?
I do. There is a case that I've cited in my response, and I'll give you that now. It's New York Cent. I'm not sure what that abbreviation is, but New York Cent and Hudson RR Company versus United States. The citation is 212 US 481 at 493 through 495. Year is 1909. With regard to vicarious liability, a corporation is held to be civilly and criminally liable when the tortious acts of its agents benefit the corporation. And that's true even if the corporation was not aware of the actions of its agents. And the standard is that the corporation benefited in some way from the acts of the agents. I'm alleging that Hockaday benefited from the actions of Ms. Michalopoulos and Ms. Dunn in preserving the reputation of the school, which was inextricably commingled with the reputations of both Dunn and Michalopoulos, since both of them were successive board chairs. Both of them were the chief executive officer at Hockaday. There was no higher authority at Hockaday than the chair of the board than Michalopoulos was at the time, and Dunn before her. And of course, Dunn stayed on the board for 2 years after her rotation as board chair there. So
the case that you just cited the court to, you reference when tortious acts of the agent benefit the principal, you think that there can be a basis for vicarious liability. What is the tort that you have alleged that they have engaged in to the benefit of the Hockaday School?
Well, intentional infliction of emotional distress, number one. Fraud, number two. There was financial harm done to me by the fraudulent order. I will again state unequivocally that the order issued by Defendant Plumlee on November 17, 2016 was void for lack of jurisdiction. I've removed my case to federal court under section 28, section US Code section 1443. There were no procedural anomalies. All of this is pled in detail in my motion for declaratory judgment, which is before the court but has not been heard yet, and also in my notice of fraud on the court, which I filed subsequent to the dismissal hearing for defendant Finley, Rochelle, and Dunn. So there are multiple underlying torts: fraud, personal injury, and also constitutional rights violations with regard to both that order of November 17, 2016, and the order issued by defendant Diaz under identical circumstances on June 7, 2018. I would like to touch briefly on what Ms. Littman said, that no court has ruled that that order is, that my claims that the order was void, that ruling has never been made by another court in this country. That's true. No court has ever ruled on this issue. The Supreme Court has not ruled on this issue. No appellate court has ruled on this issue. I will also state, as I've stated in my motion for declaratory judgment, a void order does not require a court to declare it void. If it was issued without jurisdiction, as the documents and court date stamps clearly indicate, the courts had no jurisdiction on those dates. Those orders were void, they were fraudulent, and they have no legal standing. Therefore, as I've argued in those pleadings as well, the judges had no immunity, and any co-conspirators who conspired with the judges Plumlee and Diaz in those acts are liable for those torts as well, for being co-conspirators.
Is it your position that, well, what I understand the position to be is that the Hockaday School is liable for the acts of its agent under theories of intentional infliction of emotional distress and fraud, because ultimately the school decided that it would follow orders that you believe are void and that you informed them were void. And even after you told them that you believe the orders were void, their persistence in following the orders is what you say is the basis of those claims?
That and the two different issues are separated by time, of course. I notified Hockaday in direct response to your question. In the aftermath of the issuance of defendant Diaz's purported orders of June 7, 2018, I sent them actually a pleading in my federal appeal at the time, which laid out the basis for those claims. So they had all the case law. Obviously, Hockaday has counsel, competent counsel. Stuart Bumpus is was their general counsel. I know him to be a competent attorney. Any attorney could look at these and would know by training that these orders were void because they had them. They could or should have looked at them. They had the case law, which stated that these orders were void. They chose to recognize these purported orders as legitimate when they were not. So yes, they then became a co-conspirator. In the same way, slightly different circumstances, but with the same type of order issued without jurisdiction in November 17, 2016. That order that defendant Plumlee issued violated my constitutional right to free speech, infringed my 14th Amendment right to parent, and imposed financial levies against me illicitly in excess of $55,000. That's financial fraud. And this, again, I'm alleging that is a groundless suit, a malicious prosecution that was instigated personally by Miriam Malopoulos in conspiracy with defendant Dunn and defendant Rochelle. And their conspiracy is a meeting of the minds and a common purpose and an intent to harm and a carrying out of those actions and a resulting damage. And all of those things occurred to me. And it's right there in that email. The protestations that there was no conspiracy is ludicrous. Any even half-witted observer would look at this email and say, obviously these people were conspiring to violate my rights. The litigation history, as I just mentioned, from 2013 in family court to the 2015 civil court case to the 2015 custody modification suit that Dunn filed without grounds, to Dunn's 2018 modification suit, she again filed without grounds in violation of Texas rules of civil procedure. All these things indicate a concerted and persistent conspiracy to violate, at the very least, my First and 14th Amendment rights. So I think there's plenty of evidence to show that there was a conspiracy, that there were tortious acts, fraud, constitutional violations, personal injury, infliction of emotional distress. So yes, there was a a conspiracy involving state actors in both of these incidents and everything that went on really from 2018 to the present.
Well, that's part of the reason why
Yes.
I've been asking you these probing questions,
Mhm.
because on the one hand, you allege that Ms. Michaelopoulos sent this email to Ms. Dunn and her attorney,
Mhm.
where she queried whether they ought to get a protective order and told them her belief that the school wasn't going to take any action.
Mhm.
So on the one hand, you complain about that conduct and say that that conduct is what precipitated the filing of the case against you in the 191st. And then on the other hand, you say that they were the Hockaday School's agents were in a conspiracy with the judges, Diaz and Plumlee, in connection with the family court case, which of course is not the 191st. And so that's the reason why I was trying to get a better understanding, because, you know, as you know, the rule says a cause of action has no basis in law if the allegations taken as true, together with inferences reasonably drawn from them, do not entitle the claimant to relief. A cause of action has no basis in fact if no reasonable person could believe the facts that are pleaded. And so understand that the court, you know, has that standard in the backdrop, and I'm trying to get a clear picture from you of what the way you see this, and in the face of an email where the person who's sending the email is saying that the defendant, who's before the court right now in this motion, they're not going to do anything. Maybe y'all should do something. That's what she's saying in this email.
Yes, Your Honor. And just to address that again, as I said, obviously Hockaday consists of various moving parts. There's the Hockaday administration. I know there's sort of a firewall. Well, at times there should be, but sometimes there's not, because I've witnessed how Hockaday operates from the board level on the inside, having been married to Ms. Dunn at the time she was board chair, and having friends who served on the board and still serve on the board there as well. Hockaday is not just one person or one entity. There's the administration, there's the board at large, there's the executive committee, which really controls what the board does, because the board, as I said in my response, the board took no action to correct or discipline either Dunn or Michaelopoulos after I informed them in multiple emails of the conduct of Dunn during the divorce, and also the conduct of Michaelopoulos becoming involved for some reason in the divorce involving two Hockaday parents of a Hockaday student. I'm not sure that's ever happened. I'm sure the board wouldn't have, you know, if you asked them individually, may not approve of that or think it was outrageous, which I certainly do. But I think what Michaelopoulos is saying is the board at large might not do anything legally, but that doesn't mean that that Michaelopoulos is not an agent and that Dunn is not an agent of the school. They absolutely were. The board chair is the chief executive of the board of trustees and therefore the chief executive of the school. I am arguing that even if the rest of the board did not know what Michaelopoulos was doing and what Dunn was doing in filing these groundless suits in an attempt to violate my constitutional rights, they still benefited because, as I said, Michaelopoulos raised $100 million for Hockaday during the Centennial campaign. Obviously,
but Michaelopoulos did not file any suit against you.
she did not. Michaelopoulos did not, but as this email shows, she was conspiring with Dunn and her attorney. Why was Michaelopoulos even communicating with Dunn and her attorney regarding me, unless she was conspiring in that legal action? There's no other conclusion. You know, any reasonable person, I believe, would conclude that when the Hockaday board chair is emailing the prior Hockaday board chair, who's still serving with her on the Hockaday executive committee, and her attorney suggesting that they file for a protective or gag order, that they are conspiring. I don't think any reasonable person could look at that and say that they were not conspiring against my rights. I would like to get into the mechanics of how they conspire with the state actors under my claims. And I believe I've stated that in my pleadings, in my motion for declaratory judgment, but I'll get into it just briefly here. On November 17, 2016, I removed my case to federal court, and I served Miss Rochelle, Dunn's attorney, outside the doors to the courtroom, told her the case had been removed, showed her the documents, gave her a copy of the removal documents with the date stamps on them. And Rochelle went in, handed a order for Defendant Plumlee to sign. Judge Plumlee signed that order without jurisdiction. The two of them clearly knew that what they were doing. In fact, you know, Rochelle certainly did, and the case docket, of course, would have shown the removal as well. And Defendant Plumlee had multiple opportunities after the fact to reverse that ruling, and she's been served on every federal and state appeal since then, so she knows exactly what the question is, and has made no attempt to correct or amend that ruling. The same thing happened when on June 7, 2018, I removed my case to federal court. State court lost jurisdiction. I served Defendant Findley in the courtroom, Defendant Diaz's courtroom, with the removal documents, informed him that the case had been removed. And he still proceeded, handed an order for Defendant Diaz to sign, which she did in violation of the law. I then filed a special appearance challenging jurisdiction. So Defendant Diaz knew plainly that the case had been removed and she had no jurisdiction when she signed that order, but she denied that special appearance, and Defendant Plumlee subsequently denied a de novo hearing on that special appearance. So all of these people, clearly there was a meeting of the minds to offer and sign an order in both of those dates, violative of my constitutional rights to free speech and right to parent. It has resulted
What does that have to do with the Hockaday School or its agents?
As I said, Michaelopoulos is an agent of was an agent of the Hockaday School, at least from 2011 through 2017. But in this trend, but the involvement of Hockaday transitioned from the direct involvement of Michaelopoulos and Tally Dunn from probably the day my divorce started until 2017, to Hockaday knowingly, after I had informed them and sent them the case law and the pleadings and the timeline of my removal and the jurisdiction that the court had lost, and still signed an invalid order. Hockaday still, the administration now, which is another, as I said, another part of the school. These things are inextricably intertwined. The administration at this point then stated that they were going to observe this order and indeed keep me off campus. And I want to say that Ms. Littman mischaracterized my petition. She stated that there was no allegation in my petition that Hockaday would enforce that order and call the police against me, but that's on paragraph 150 on page 60 of my original petition, and paragraph 180 on page 75. Hockaday did state that they would enforce this invalid order, knowing that it was invalid. And at that point, the Hockaday administration became a co-conspirator in a conspiracy involving a state actor, Defendant Diaz, at that point, who had signed an illegal order without jurisdiction. And then Hockaday knowingly chose to become involved in a conspiracy to violate my rights by keeping me from the Hockaday campus, and therefore from my daughter, violated my First Amendment right to free assembly and my 14th Amendment right to parent. So Hockaday comprises the administration, the board at large, the executive committee, and certainly the agents. All of these could be considered agents of the school and are therefore vicariously liable for civil damages.
So in terms of the key points in the timeline here, and I'm not suggesting that the other dates are not important. I'm just seizing on these and focusing on these for right now. Ms. Michaelopoulos sent the email back in November of 2014, and 2 years later, in November of 2016, Judge Plumlee signed an order that you believe was void. And then again, on June 7th, 2018, Judge Diaz signed an order that you believe is void. And you feel that there was a conspiracy to get by agents of the Hockaday School, namely Ms. Michaelopoulos, who sent this email to get them to sign these void orders. And then as a corollary to that, after the orders were signed in 2018, between August and November, you exchanged emails with the CFO of the Hockaday School. I think it's, I don't know if it's Mr. or Miss Coates.
Miss Coates, yes. And the head of the school as well, Miss Coleman.
Okay, and in those emails, you informed them of your legal assessment of the orders and that you believe that they were facially invalid. And they wrote you late November and said, we're going to observe the orders. And that you believe is their conspiracy to work with the state actors, the judges, to perpetuate the deprivation of your constitutional rights.
Yes, Your Honor. And the direct link between the state actor, Judge Diaz, and the Hockaday School was Defendant Finley and Defendant Dunn, one or both of whom emailed probably or sent in some way that order, a purported order of June 7th, 2018 to the school. So they weren't in the same room. However, they were operating with the same goal and in the same conspiracy.
So either Ms. Dunn or her lawyer forwarded the orders to the school to say, hey, these orders are in place. And then the school said, basically, unless they get something that shows the orders have been vacated or overruled or something like that, they are going to enforce the orders.
That is correct, Your Honor.
Okay. Let me just see if I have any other questions for you, and then I'll give you just a couple of minutes to wrap up before I give a final reply to the move-in.
Mm-hmm.
All right. I think you have answered my questions. Anything else for the last couple of minutes, Mr. Miller?
Yes, I'll see if there's any legal questions that I haven't covered yet.
Sure.
I do want to reiterate that I believe this motion to dismiss is nothing more than a calculated attempt to avoid responsibility for tortious and criminal acts committed and performed by its agents, Dunn and Michalopolis, among others, with the goal of preserving future fundraising dollars. I've covered the constitutional claims and to some degree. Ms. Lippman mentions Dennis v. Sparks, which I cited in my response, which stipulates that private persons jointly engaged with state officials in the challenged actions are under color of law for purposes of 1983 actions, and therefore defendants Plumlee and Diaz are state actors, and therefore the defendants Hockaday, Dunn, and Michalopolis conspired with them and are therefore answerable under Section 1983, in addition to 1985, as I covered earlier. There's a Supreme Court case, Griffin v. Breckenridge, which is 403 U.S. 88, 1971, which states that Section 1985.3 does not require state action, but also reaches private conspiracies. And also, there is no racial discrimination element. That was something that Mr. Findley, to Section 1985 claims, Mr. Findley brought up in a prior hearing. And the case supporting that is Arizona Democratic Party v. Arizona Republican Party, number CV-16-03752, 2016 WL 8669978 at Section 5, Note 4. And that's District of Arizona, November 4th, 2016, stating that the plain language of the statute does not require either the element of a state actor or racial discrimination. I believe I've covered vicarious liability in enough detail. As I said, again, Hockaday did benefit from the actions of its agents in violating my constitutional rights, and therefore the school is civilly liable. With regard to fraud, I want to clarify that a little bit. As you touched upon, I believe Hockaday and I'm alleging that Hockaday made the representation directly to me that Judge Diaz's purported temporary orders of June 7, 2018 were a legitimate court document. That representation was false, which I believe all the facts have demonstrated, regardless of whether another court has ruled on it or not, which they haven't. No court has ruled that is not the case. No court has ruled on the validity of these orders. And I actually have tried multiple times, but of course the Fifth Court of Appeals has avoided that hot potato, I believe, to protect Judge Plumlee. And also, and they knew those orders were issued without jurisdiction. And when Hockaday made the representation, they knew it to be false because I had notified them, as we've covered in various emails and in case law and in by forwarding pleadings to them from my federal appellate case at the time. Hockaday made the representation with the intent that I act on it by staying away from campus, which I have, because they threatened specifically to call the police to issue a trespass warning against me. I did rely on that representation, and I have not been on the Hockaday campus for 3 years now. And that false representation has indeed caused me injury. As I said, I've missed 3 years of my daughter's school events, and I've been deprived of interacting with the community at Hockaday in my daughter's class. So I believe I've established the elements of fraud beyond any reasonable standard. With regard to third-party fraud, I covered this in a pleading on third-party, specifically on third-party fraud case law. I don't believe it's necessary that an injurious false representation be made directly to the injured party, which would be me. The language in Texas case law is largely generic with regard to the party who hears the misrepresentation. And for example, I cited this case before in other pleadings in Ray First Merit Bank in that's 52 Southwest 3rd, 749 at 758. That's Texas Supreme Court, 2001. And there's also precedent in other states that has established that a misrepresentation made to a third party that injures a complainant meets the standard for fraud. And those cases are Minnesota Supreme Court cases, there's a Minnesota federal case, I'm sorry, VIXA, that's VIKSE v. Flaby, 316 Northwest 2nd, 276 at 284, that's 1982 in Minnesota. And then second case is Luckey, Luckey versus Allside, and that's my pleading as well. 245 Federal Supplemental 3rd, 1080 at 1094 in the District of Minnesota, 2017. As I've also mentioned before, Texas Penal Code section 32.46 in the chapter titled specifically fraud, specifically outlaws securing execution of document by deception and thereby harming a third party. So it would be illogical to claim that civil fraud requires that a harmful misrepresentation be made directly to an injured party when the criminal law outlaws making it to a harmful misrepresentation to a third party. Thus, I'm alleging that a false representation made by agents of Hockaday, Dunn, or Michelopolis to a court or to another person or entity which caused harm would certainly meet the standard for both fraud and vicarious liability, as I mentioned, as far as Hockaday is concerned. I've covered conspiracy earlier. As I said, conspiracy is just two or more people acting together with an objective, a meeting of the minds, an unlawful act, and damages caused as a result, all of which I've covered in great detail in my pleadings and today as well. And the standard there is a Texas Supreme Court case, Massey v. Armco Steel Company, 652 Southwest 2nd, 932. That's Texas 1983. And of course, I've covered ad nauseum that there was a conspiracy. And I've described how that conspiracy existed back in November of 2016 when Judge Plumlee issued that purported order, and in June 7, 2018, when Judge Diaz issued her purported order as well. All of these defendants, Michelopolis, Hockaday, Dunn, Findley, Rochelle, Judge Plumlee, and Diaz, they knew that they were committing crimes by securing execution of a court document by deception when courts had no jurisdiction, and then falsely representing these documents as legitimate. They intended to harm me by doing so, and each knew eventually, if not immediately, that the others intended to harm me, which they have done. I kept them all notified by email and various other ways, and personal meetings as well with Hockaday. So clearly they all knew eventually, or in short order, what the others were doing. Miriam Michelopolis is an SMU law graduate. She's a trained lawyer. She would have known that filing, or should have known, and certainly did know, certainly she did know, that filing a groundless lawsuit violated state law, both Texas Family Code section 156.101, as well as Texas Rule of Civil Procedure, Rule 13. And she must have known and intended to harm me by filing such a suit. As I've covered, Hockaday's decision to knowingly observe these fraudulent orders made the school a party to a conspiracy. Thus, conspiracy is well established. I want to get into an intentional infliction of emotional distress. The suggestion that there are no allegations supporting intentional infliction of emotional distress is absolutely ludicrous to again, to even the most naive observer, it strains any standard of credulity. As I said, Defendant Michaelopoulos, while board chair, intentionally instructed her fellow board executive committee member Dunn to file groundless suits against me to get a gag order, injuring my rights. There's no doubt as to her intent. Separating a parent and child for 3 years, as I have been from my daughter without grounds, certainly qualifies as extreme and outrageous conduct under Salazar v. H-E-B Grocery Co., which is cited in Ms. Littman's pleading, actually, and any other standard for case law, which I've cited in my own pleadings. When people engage in such behavior outside of court, it's called kidnapping or child trafficking, and it's really difficult to imagine any conduct more outrageous than keeping a child away from a caring and fit parent without any grounds whatsoever. There have not been any grounds in Dunn's suits or in the court orders issued or void court orders issued by defendants Plumlee and Diaz stating why I should be kept from my daughter or have supervised visitation. It's just that Dunn wants it and they sign it. This is really the conduct of sadists. Beyond that, Defendant Dunn's 2015 modification suit, which I indicated was instigated by Defendant Michaelopoulos, caused me to spend the next 2 or 3 years of my life defending myself in court, which eventually led to the deprivation of all of my money and to my arrest and prosecution for falling behind on child support payments. Clearly, I was undergoing a lot of emotional distress at this time, which I will state unequivocally now. Even worse, I've been kept from seeing my daughter at school by Hockaday's decision to observe and enforce Defendant Diaz's fraudulent temporary orders of 2018. I've documented my emotional distress extensively throughout my original petition, as well as in my pleadings and in various other tangentially related court cases. Such a campaign of abuse and harassment against me could only result in emotional distress. It's hard for any observer to look at this and conclude otherwise. Hockaday knew or must have known that my suffering was a primary risk of their decision to harass me with these groundless suits and with their decision to observe these fraudulent orders. Fourth, it's difficult to imagine any emotional distress worse than the feeling of having your only child taken from you without grounds and not seeing her for 3 years, and also witnessing your daughter's school engage in a conspiracy to violate my First and 14th Amendment rights for at least 7 years. It's unbelievable. As I wrote in my original petition, the sheer depravity of this conduct is unimaginable. That's on page 12 of my original petition. No reasonable person would find the conduct of Dunn, Michaelopoulos, and Hockaday generally to be normal. It is extreme and outrageous by any standard. Thus, I believe I've met the elements of and standard for intentional infliction of emotional distress, and the resulting damages are also recoverable. I believe that's all I have for you, Your Honor.
Thank you, Mr. Miller. Ms. Littman, I'll give you an opportunity for a final reply.
Sure, Your Honor. I mean, I think you've got the timeline down and sort of understand the basis of what I believe are Mr. Miller's, the basis for his claims. I would just say on his last point on the, I mean, several times he continues to talk about the Hockaday harassing him by the filing of these groundless suits. But as you pointed out earlier, Hockaday nor Ms. Michaelopoulos ever filed any lawsuit against Mr. Miller. With regard to the intentional infliction of emotional distress, I have no doubt that Mr. Miller has suffered distress over these actions, but there are no factual allegations to support any claim that Hockaday is the cause of them. And Mr. Miller, he pointed out this particular paragraph to you a few minutes ago. He pointed it out saying that I had mischaracterized or misrepresented something that Hockaday did state that they would call the police. And it's paragraph 180 on page 75. And actually what it says is JT Coates replied via an email, "We will continue with the protocols described in the August 21st letter until we receive an order rescinding the current TRO." There's no allegation that Hockaday was abiding by those, or keeping him off the grounds for any reason other than the TRO. They were not acting in any extreme or outrageous manner merely by following a court order that the only person who claimed it to be invalid was Mr. Miller. And again, Your Honor, there's just no basis to hold that Ms. Michalopoulos's statements to Ms. Dunn and her attorney were made on the behalf of Hockaday. I mean, if that was the case, no one could ever serve on a board and have a personal or professional life outside of the board. And people could not engage in conversations about protective orders without the fear of being sued like Mr. Miller is suing. And one point, Mr. Miller said he couldn't understand why Ms. Michalopoulos would have even been conversing with Ms. Dunn and her attorney about him. But the reason, Your Honor, I believe is what prompted her email on November 9th to begin with, when he emailed Ms. Michalopoulos, David Hamasager, and Ms. Michalopoulos's law partner with a page email disparaging Ms. Dunn. And thereafter, it appears that Judge Slaughter agreed and said that it was clear that Mr. Miller was attempting to harm Ms. Dunn, and that was the reason that she issued an order against him. So for all of the reasons that I've argued and that are set forth in our Rule 91A motion, we would ask that you grant the motion and dismiss all claims against Hockaday with prejudice.
There are a number of issues raised with this record, including the issue with the motion for leave, the exhibits, and the motion itself, a request for expedited discovery, all of those things. And so, Ms. Littman, my question for you is, have you submitted proposed orders to the court that the court can work from in terms of making rulings?
I did submit just the initial proposed order, Your Honor, which was just to deny the motion. And it's submitted in a Word format. So if you want to revise it, or I'm happy to revise it and include a granting or denying of the motion for leave. I did not do one on the motion for expedited discovery because it seems like it was moot because it could not be heard prior to now. But if Your Honor would like for me to do that, I certainly will.
Well, I do think it's important for the order to reflect the court's ruling related to, I mean, I've made it here on the record as Mr. Miller urged me to do at the start of the hearing, but I just like to put it all in the order. And so that was the main thing. Secondly, let me just try to wrap us up here. Mr. Miller, this is a difficult situation because in some ways, because Mr. Miller, it is quite clear to me that you feel very strongly that certain things happened and certain people did it, and that they were engaged in certain activities intentionally to hurt you and harm you and limit your rights and your relationship with your daughter. And certainly, as Ms. Littman acknowledged, no one disagrees that it would create emotional distress to not be able to have the relationship with one's child that you desire, whether that be unsupervised and unfettered or otherwise. No one is challenging, certainly not me, that it is a source of emotional distress for you, your current circumstance as it relates to your child and as it relates to where you are after a divorce. Like many people, it's not fun, and it sounds like it's been a very difficult time. And I in no way mean to minimize that with any of the questions that I ask you. I ask the questions because you all submit significant records to the court. I try my very best to get my hands around everything, but I also want to make sure I'm not missing something or misreading something. And so that's a large part of the reason why I ask you the questions. And because it is your case, I ask probably more questions of you than I ask of Ms. Littman, because it's important to me that I make sure I'm hearing as I've read your brief, clearly what you've said with what I've read. Where we are, though, from a legal standpoint, is that you have attached these emails that almost contradict the contentions that are in the case about the Hockaday School's involvement. In both of the emails that are attached, Ms. Brousseau, as she is named in the emails, says that she's not, in the first email, November 10th at 3:11, she says, the only action I intend to take is to write the board chair and explain that because this involves parents and children, it's improper for me to address it and he should speak to the head of the school. And then that later that day, she sends this sort of afterthought inquiry to the lawyer where she says in a question, what if you move for a protective order? And that's what we've got with regard to her. And then months later, an action is instituted by your ex-wife to try to get these emails to stop, apparently, that was filed in the 191st. And then we move to the other end of the spectrum where the Hockaday School gets an order from Ms. Dunn and her lawyer that is signed by a district judge that says, this is the way that you must conduct yourself as it relates to this child. And in the face of nothing that says that order has been rescinded or vacated or overruled or reversed in some way, they elect to follow it, even in the face of you telling them that your assessment is that the order is void. And so those are really sort of the two buckets of conduct that we're talking about relative to whether they got together with judges, the family court judges, to conspire against you, and on the other end, whether they engaged in fraudulent activity or that was intended to deceive you and induce you to behave in some manner that was harmful to you, and whether or not they intended to inflict emotional distress on you. And that's why I reminded you of that standard that's set forward in the rule, because that's what the court is balancing all of this against. So I just wanted to wrap us up by making sure that you know that I have read the things that you've submitted. I have looked at this record. I asked you a lot of questions because I want to make sure I'm getting your position right. And because, as you've reminded the court in your filings, you are representing yourself. And so I try to spend a little bit more time asking you questions than I would a licensed attorney who submitted a brief. So with that, the court will get a ruling out with regard to this matter. I would like a proposed order to work from Ms. Littman, as you've indicated, and of course, be sure to copy Mr. Miller on any proposed order that you transmit to the court pursuant to my request here. If there is nothing further this afternoon, you all are excused.
Well, one issue, Your Honor,
yes,
I did submit a proposed order on my motion for leave to file. So you should have that
Okay.
for you.
Well, if we've got an order then that the court can sign related to the motion for leave, and we have another order related to the motion to dismiss, then Ms. Littman, you don't need to send me anything else. I can just use those two orders to deal with both issues rather than putting them in a single order. So no need to create more work for anyone. I'll do that. Thank you for bringing that to my attention, Mr. Miller. If
Thank you.
there
Your
is
Honor, there
nothing-
is one more thing.
I'm sorry, Mr. Grayton. Yes, sir.
Next week, there is a hearing scheduled on Mr. Miller's motion for declaratory judgment. The judgment itself seems to be directed towards defendants Judge Plumlee and Judge Diaz, who have been dismissed from the lawsuit, and the relief that he seeks is related directly to defenses or procedural arguments, jurisdictional arguments that have been asserted already and ruled upon by the court. And I'm just trying to find out if the court still intends to have a hearing, if there are any defendants left in the lawsuit who such declaratory relief could even be entered against.
Your Honor.
These defendants have been dismissed already.
Okay. Mr. Miller, go ahead.
Yes, Your Honor. As far as I know, Defendant Diaz has not even filed a motion to dismiss and has not been dismissed from this suit. Judge Plumlee was dismissed, but not Dallas County and Judge Diaz. And also, as long as the court has jurisdiction, declaratory judgment can be sought at any time. So I believe that hearing should certainly go forward.
Yeah, I'm just looking at my list. I try to keep track of who's in and who's out with my list based on the motions that get filed. And certainly today, Mr. Braden, you entered an appearance on behalf of Judge Diaz and Dallas County. And I didn't have Judge Diaz. I don't have a line through Judge Diaz's name in the start of the case, which is an indication that the court has not heard a motion related to Judge Diaz. Am I mistaken in that regard?
First of all,
Your
Your Honor,
Honor,
I
this
do not
is-
represent Judge Diaz.
Your Honor, this is Earl Nesbitt. We represent Judge Diaz and Dallas County. You
I'm
are-
sorry. You're
That's all
right.
right.
I'm sorry. I'm sorry, Mr. Nesbitt. I recall that. You're right. I'm sorry. I misspoke with regard to what's on my notes. Go ahead, Mr. Nesbitt.
Well, Mr. Miller and the court are both correct, and we've not filed a motion to dismiss or plead the jurisdiction as yet. It is coming, but, you know, the court can do what it needs to do. We have not moved or asked for dismissal or asked the court to dismiss for lack of subject matter jurisdiction yet.
All right. So
I
I
stand
don't know.
corrected.
I haven't read the motion for declaratory judgment yet, because you can imagine I have a lot of stuff to read every day. So I just try to focus on the docket that's in front of me. So I haven't read for next week's docket yet. So if Mr. Miller's motion for declaratory relief is directed at the rulings that were made by Judge Diaz or other defendants in the matter, then of course it will be on the docket and the court will hear it.
Thank you, Your Honor.
Thank you. All right, everyone. Thank you again for your time this afternoon. You are excused.
Thank you, Judge.
Thank you. Bye-bye.